This is Bloomberg Law with June Grasso from Bloomberg Radio.
A huge defeat for Google and a huge win for the government in its first major antitrust case against a tech giant in more than 2 decades. A federal judge has ruled that Google is a monopolist that illegally monopolized the online search market through exclusive deals. And the sanctions for Google? Those could range from a breakup to unwinding exclusive search deals. But that won't be decided until after another trial, which has yet to be scheduled. And of course, Google says it will appeal the decision. Joining me is antitrust expert William Kovacic, a professor at the George Washington University Law School and the former chair of the Federal Trade Commission. Will this decision stand as a landmark along with, say, the AT&T, Standard Oil, and Microsoft cases?
It's the beginning of a process that could become a landmark, but there's still many rivers to cross before this specific contest is over. We have a proceeding coming up this fall on the remedy to be issued. Judge Mehta will be writing an opinion on what that remedy should be, probably issues that by the end of the year. But then we go through the inevitable process of appeals, where Google and maybe the government plaintiffs decide to appeal different issues, raise different points about Judge Mehta's decisions on liability and remedy. So this promising first step for the government is only the first step in a process that will lead through a fairly difficult gauntlet of appeals. And I think ultimately this is a case that gets to the U.S. Supreme Court. The Supreme Court hasn't informed me about whether that's the case. So this is speculation that I can't defend in any scientific way. But it's a case of such significance, both with respect to doctrine and commerce, that it's a natural candidate to be reviewed by the Supreme Court. And that process could take us well into 2026. So your crucial question about what kind of landmark this is, I will answer with the typical academic's evasion. It depends on the final resolution of the matter through the appeals, an answer that won't come to us probably for 2 more years.
Judge Mehta found that Google is a monopolist and has acted as one to maintain its monopoly. Can you explain broadly how he came to that conclusion?
On the crucial question of monopoly, the government has to show that the company exercises tremendous power within an area of commerce. And in antitrust language, that's usually called a relevant market. It's a technical term that refers to products that people regard as good substitutes for each other. And the government, to Judge Mehta's satisfaction, proved that in a market consisting of general search services, that Google indeed is a monopolist, that it does not have effective competitors, that it accounts for an overwhelming share of activity of searches that are carried out. And as a consequence, its power is not only significant today, but the court concluded it's going to be durable. But in U.S. antitrust law, it's not enough to simply be big. There are lots of expressions by courts over time that saying achieving a position of preeminence is a mark of distinction. It's not a badge of shame. So you have to do something more. You have to show that that power was achieved through means that are improper, that you achieved it through improper means, you protected it through improper means. A colleague once told me that it means in U.S. law that you need not only be big, you have to be bad as well. And on that point, Judge Mehta found that Google's behavior in a number of instances was improper, that it excluded rivals from having access to business opportunities that they needed to compete. And it did it through a variety of different forms of exclusivity agreements that gave it the sole access to a crucial asset in dealing with third parties such as Apple, and it meant that competitors didn't have the opportunity to use that valuable asset to compete effectively with Google. So for those 2 core elements of the monopolization case, Judge Mehta validated the heart of the government's theory. That in all respects, Google has some things in this opinion that it I'm sure likes. Disappointed with the larger outcome, I imagine. The government did not get everything it wanted here, but it got validation of its core interpretation of this crucial principle of monopolization law, that the firm in question must indeed have tremendous power within a specific part of the marketplace and must have achieved or protected that position through improper means. On those larger themes, Judge Mehta concluded that the government had proven its case.
Google plans to appeal. no surprise. And in a statement said that, and this goes to your point, that Meta's opinion recognized Google as the internet's best search engine, quote, but concludes that we shouldn't be allowed to make it easily available. Do you think Google has a lot of ammunition for appeal?
It enjoys a couple of potential advantages on appeal, and a couple of that aren't merely potential, they're real. The law, the jurisprudence of U.S. antitrust law going back over a period of since the late 70s has tended to err on the side of dominant firms in evaluating their behavior. It has not told them they can do anything they want, but it's imposed fairly severe burdens on government and private plaintiffs trying to attack the behavior of dominant firms. So that the arena in which the appeals will take place is one in which the doctrine is generally sympathetic to the kinds of arguments that Google has offered about its own work in just the last 24 hours and developed during the trial. Another advantage is that they'll point to the evidence in the record that suggests that people turn back to Google when they have a choice. When the starting point of their experience is another product, they switch to the default. They abandon that product and turn back to Google. So Google's going to say there's evidence in the case that says people come back to us because we're offering them the better experience. Those aren't silly arguments. Those are arguments that enjoy some philosophical and doctrinal support in what courts have done in the past. So Google will be standing before the Court of Appeals saying that the practices that the government complains about cannot appropriately be deemed to be improper. And the remedial hearings, will focus a lot on what Google should be allowed to do in the future. How much should it be able to bid for, say, the placement on the iPhone when it comes to the famous rectangle on the iPhone? Should it be more cautious in how it bids? Should it bid less aggressively? What exactly should its position be? Those are hard issues to be resolved in the remedial proceedings. And Judge Mehta, in a couple of places, in an opinion, expressed a concern that has appeared in earlier Supreme Court decisions about the difficulty judges face in trying to tell companies whom they must deal with and on what terms they must deal with them. It expressed concern about mandating a general obligation on the part of dominant firms to deal with other companies. Anxiety about the role that courts would undertake in becoming a referee that examines and evaluates each of these interactions between the dominant firm and a third party. The court said, we're not well suited to do that. The intervention that we have to undertake has to be much cleaner and not involve such long-term ongoing entanglements. We can't do that. During the remedy proceedings and probably in the appellate process, Google will be saying, well, in light of that expressed concern, how do you write an order or an injunction that tells us what we can and can't do without, in some crucial ways, just disabling us? How do you do that? So those would be very live and important issues for debate during the appeals. And as we mentioned before, we're probably about 2 years away from a final decision, if I'm right about the likelihood of Supreme Court review as the last stage of the process.
It sounds as if, and I could be wrong here, that you think that Google has the better arguments on appeal?
I don't know in substance that they have the better arguments on appeal. I just think a caution to keep in mind in some ways amid the euphoria that many felt yesterday about the outcome, those who wanted the judge to find liability, the caution I simply express is that there's a lot of hard work to be done in defining what it is Google can't do in the future. And Google's operating in a judicial environment, a doctrinal environment built up, especially since the late 1970s, that tends to be sympathetic to some of the kinds of arguments that Google has been making. So it's really a caution that, notwithstanding the exceptional result that the government achieved yesterday, that there are many rivers to cross before the final outcome validates the approach that they've been taking. And Google is not yet defeated in its efforts to persuade the appellate judges that it didn't behave improperly.
So you mentioned the remedies, and Judge Mehta's scheduled a hearing for next month to decide the timing for the separate trial on the remedies. And potential remedies mentioned have been everything from ordering a breakup of Google to unwinding exclusive search deals, everything in between. What do you see as the most likely potential remedy or remedies?
A starting point is likely to be controls on conduct. That is, to define the types of agreements that Google cannot enter into in the future, to indicate that certain types of existing agreements or practices are no longer permissible, with the caveat that writing the injunction that prohibits those practices will require a lot of further attention and thought in light of some of the concerns that we've just been talking about. The bolder, in some sense, the more visually striking solution is to force the company to divest assets. That's the breakup solution. Theoretically, it's in the solution set. It's a well-established antitrust remedy for monopolization going back to the earliest phase of enforcement of the Sherman Act in the late 19th and early 20th centuries. It's also been a remedy that courts have applied with some reluctance, some anxiety on the part of individual federal judges about whether they are performing surgery of a sort that's going to make the commercial system better or worse off. So I would say there's an implicit additional burden that government plaintiffs carry when they're trying to argue for divestiture remedies in monopolization cases. It's not impossible to bear that burden. In the famous DOJ prosecution of Microsoft, DOJ succeeded in persuading the trial judge to mandate the separation of Microsoft into two parts, an operating systems company and an applications company. The Court of Appeals rejected that remedy for a variety of reasons. One of them was that Judge Jackson, the trial judge in the case, held an adequate set of hearings on the remedy. He basically had a 2-hour conversation with the parties in the courtroom, and that was it. But he should have done more. The court also did not uphold the full scope of the finding of liability that the district judge had found at the trial, and it said that we've narrowed the footprint of the finding of liability. You have to take that into account in deciding the remedy. The Court of Appeals didn't say you can't mandate divestiture, but be cautious. Be careful in designing the remedy because our finding of liability is narrower than the one that you found. That was perhaps an oblique way of the court saying, don't come back to us with a breakup solution. So conceptually, legally, theoretically, it's part of the solution set. In practice, it's been a challenging remedy in some instances for the government to obtain. I'd say to get the remedy, the government has to do two things. One is to say that the misconduct created serious competitive flaws in the relevant line of commerce, seriously retarded competition, and that the structural solution is vital to restoring competition and making it effective in the future. Not impossible, but very challenging, which tends to mean that a more likely outcome perhaps is some set of controls on conduct rather than mandated divestitures.
In a statement, Attorney General Merrick Garland said, "This victory against Google is a historic win for the American people." I mean, is it really a win for consumers who seem to be happy with Google even when presented with alternatives?
It could be, but we don't know yet. First, it's too early to say because this case isn't over. There are other rounds to this contest to be played out. In that sense, it's hardly over. But embedded in all of these cases, in some ways, is an act of faith that the intervention is indeed going to spur a greater level of innovation than would have happened otherwise. You know, there are some good historical examples to show that act of faith was justified. Sometimes it doesn't quite turn out that way. I suppose if I were the Attorney General, I'd make the same claim, but he can't know that yet. We don't know that yet. It's certainly a possible outcome, but it's a very strong claim. And if I were him, I'd be making that claim too. But perhaps keeping in mind, quietly and privately, that we don't know. And part of what's difficult about the whole field is that uncertainty is real and significant.
Do you think this decision will in any way influence the other government antitrust lawsuits against big tech?
I think that the decision is likely to have some favorable spillovers to the other government monopolization cases running now involving tech. I think that judges in the other cases will read Judge Mehta's decision very carefully. It's a very thoughtful opinion. I think that they'll refer to it, they'll think about it, so it's likely to exercise some influence over their thinking. Internationally, Google is the subject of a myriad collection of regulatory and antitrust law interventions globally. Everything from the Digital Markets Act in the European Union to monopolization cases and investigations in Asia and Africa and Latin America, in Australia, and now, of course, in North America, too. This case provides them some encouragement to carry on. It says that the U.S. government thought this was a serious problem that required intervention, and they intervened. a federal judge thought there were serious problems here and found an infringement. It helps blunt the argument that the countries overseas are simply picking on American companies, and they're doing it for protectionist reasons. It gives them the ability to say, we are operating in a mainstream of policy already occupied by the government of the United States, and we're not doing anything different from what they're doing. It gives them some encouragement. It gives them some reinforcement for the path they've taken. And it enables them to say, if the U.S. government is taking this step, if the U.S. courts are coming up with these decisions, how can you claim that we're operating, in some sense, in an extreme or radical fashion? We're not.
Thanks so much for coming on the show. That's Professor William Kovacic of GW Law. Corporate attorneys and perhaps even judges are bracing for the impact of Delaware's new corporate law amendments that allow companies to use private contracts to grant stockholders the types of control that used to require a charter provision or a special class of stock. A state bar committee drafted the amendments in response to a Chancery Court decision in February that invalidated a billionaire founder's veto rights over board decisions. Joining me is business law expert Eric Talley, a professor at Columbia Law School. Eric, tell us about this new amendment to Delaware law.
So this is a recent statute to the Delaware Code, an amendment to the code that on some level seems kind of minor and technocratic, but on another level may end up proving to be a big deal. And what it concerns is something known as shareholder agreements or stockholder agreements, which traditionally, sort of the OG version of these things, were exactly what they sounded like, agreements among and between stockholders of Delaware companies that basically said, we're going to coordinate our actions, we're going to vote together, we're going to cooperate together, and so forth. And these have been around for a long time. And Delaware law has basically said these are completely fine. And over time, they became more and more prominent. And then what started to happen is that these OG shareholder agreements kind of turned a little bit more into what you might call a Gen Z shareholder agreement, which is that it wasn't just an agreement amongst the shareholders, but now the company was a part of the agreement, and the company also, or its board, had duties themselves for actions that boards usually do, like whether they're going to pursue financing or a new business opportunity or an M&A transaction or issuing new stock or dividends and so forth. And so these Gen Z agreements often would give shareholders, or more often just a select group of shareholders, control or veto power over whether that happened. And so that's a little bit different of a model than just certain shareholders saying we're going to agree to coordinate with each other in doing things that shareholders usually do. Now, the company's involved, and particularly what the board of the company does is involved. And that creates a tension. It puts these new age sort of shareholder agreements on a collision course with traditional Delaware law. And Delaware law is sort of the standard bearer in corporate law and has been for the last century, even though it's under a little bit of strain recently. And it basically puts forth a model of how companies, at least as a default matter, are going to be governed. And it's going to be centralized through the board of directors. The board of directors is going to have sort of centralized authority and duties to act on behalf of the company.
And how or why did Delaware get to this point?
Now, there's a reason that Delaware did that. It's long viewed itself as what's known as a contractarian state, which just means if companies want to set up, some sort of tailored governance system for themselves, Delaware will let them do it. And in fact, almost views these various governance agreements as a bundle of contracts between the companies. But corporations are complex. They have a bunch of different interests, not just stockholders and managers, but employees and creditors and suppliers and customers. And so it would invite havoc just to say, let's have a free-for-all of everyone entering contracts with one another. It would just be a complete mess because the contracts might not even, be consistent with one another. So traditionally, the Delaware approach has basically sort of mediated this by saying, we're going to put the board at the center of all things. And there's a hierarchy of contracts that are going to be used. At the top of that hierarchy is something known as the corporate charter. It's almost like the constitution of a company. Then below that is kind of another set of documents called bylaws. And then sort of contracts and board resolutions are at the end. And so if you wanted to change your company in a way that's a little different than the background rules of Delaware would lay out. You could do it for the most part, but you'd have to make sure you did it through an authoritative document, one of these high in the hierarchy documents like the charter. And that's how this collision occurred, because once parties started to enter into these Gen Z stockholder agreements, not just between shareholders, but also had implications for the board's power, there was kind of a looming Armageddon between what was going to win out, this traditional hierarchy of, hey, no, the charter controls everything, versus these contracts that are entered into between maybe just a couple of shareholders and the board, or maybe someone who's thinking about becoming a shareholder on board. They may have precedence over those traditional powers of what boards do. And so that is essentially the breach that this new statute dives into. And it ends up putting a pretty strong thumb on the scale on behalf of stockholder agreements, basically saying, even if they are inconsistent with the charter, for the most part, they're going to have effectiveness and enforcement power inside Delaware corporations. And that's what I think some people are trying to figure out. Well, how far is that going to reach?
Was this done to try to tamp down on litigation?
Well, maybe or maybe not. Certainly in the first instance, it appears that it probably was, because, there was a case that had come out that had been authored by Vice Chancellor Laster, who's one of the well-known judges on the Delaware court. And it dealt with a particular company called the monopolist Corporation that had its founder as what was one of its big shareholders. And he had entered into an agreement with the company that gave him the good part of 20 different sort of veto and control rights over things that boards usually do, but did it through a contract. And the Chancery Court judge, Vice Chancellor Laster, basically said, look, you can probably do this stuff, but doing it through a side contract and not doing it through the charter is inconsistent with Delaware law, and these provisions are going to be invalid. He held them to be invalid if they weren't included in the charter, the constitution of the company. Now, this created all kinds of havoc, because over time, people had gotten so comfortable with stockholder agreements, and they had, essentially conjectured that, these are going to be totally fine. And so they kind of ended up sort of feeding the beast of creating more and more of them. And, a lot of transactional attorneys had basically assumed that they were going to be perfectly enforceable. I think when you step back a little bit, the tension between the traditional way that Delaware law lays out the hierarchy of charters and bylaws and contracts, made this Armageddon point almost inevitable. But by this point, a bunch of transactional attorneys had already advised, hundreds, if not thousands of their clients, you can go ahead and do this, and I'll work one up for you. So I think it became a little bit of a freighted point for many of the transactional attorneys who had sort of put their name behind these stockholder agreements. And so the statute ended up doing something that is a little bit unusual. There have been cases in the past where Delaware has changed its law in response to a case that's come out. But usually you wait until the case goes all the way up to the Delaware Supreme Court and the final judgment is entered into. And in this case, the Delaware legislature, basically was lobbied to get in on the action very early on in the process, shortly after the trial court opinion came out and before the Delaware Supreme Court got a chance to review it.
Is there tension between the Chancery Court and the state bar, or, the attorneys from influential firms that you could see when they discuss the amendments in the Delaware House?
Yeah, I think that it's fair to say that there was. I mean, one of the things that's worth noting is that there's always going to be a little bit of tension between parties who are either writing or litigating contracts that end up in front of a court and the court itself. The court, basically is not taking sides in the issue, but trying to produce a coherent area of law. The thing that probably compounds it a little bit is that in Delaware, the job of proposing and putting forward new amendments to the Delaware statutes has largely been delegated out to a non-legislative committee. It's called the Delaware Council. And this is essentially a collection of lawyers who either practice in front of the court or do transactional work in the court. It's pretty heavily represented by, folks who would be writing these stockholder agreements. And they were, thrown into, I guess, a little bit of a panic from this trial court opinion. And so, they ended up, sort of putting out the proposal. The proposal proposal itself was viewed by several folks when it first came out as being, pretty radical in the changes that it might end up visiting on the law. And that caused some tension, and it caused some tension in a couple different areas. There were several people who, critiqued the speed with which this reform proposal was coming forward and had not really sort of anticipated all the different ways that it could go sideways. And in fact, there was a group of about almost 60 law professors, and I was one of them, I should note, and also kind of helped author the letter that signed a letter that said, hey, let's slow down this process and try to figure out what makes sense, because this may change a lot of things that you don't intend to change. But in addition, two of the judges on the Delaware Chancery Court, Chancellor McCormick herself and Vice Chancellor Laster, both had decided to go public about their own reservations about this statutory reform. And that ended up causing a much more heated environment than you usually see with corporate law reform. I don't recall, certainly in my academic lifetime, anything nearly as contentious as this. Usually this is a pretty sleepy area. Whether you agree or disagree with, the new statute, it ends up being sort of a thing that, people sort of say, well, reasonable minds can differ. But here, I think there really was a much more public debate than the proponent of the statutory reform had anticipated.
This amendment, do you think that it would allow boards to get too creative? Do you think that they'll just stay in the lane that they were in?
Yeah, this is actually kind of a $60,000 question right now, June. Maybe I can use a basketball analogy to
Please,
to
go ahead.
The Olympics. Yeah. So, think about playing defense on a basketball team and, whether you grab your opponent's jersey. Now, you're not supposed to do that, right? But you are allowed to put your hand on the back of your opponent to kind of take their measure. And, when does putting a hand on the back of their jersey become grabbing their jersey? It's sort of a judgment call. And so most people who play basketball, they will sort of try to push the boundaries of that rule a little bit, do a little bit of jersey grabbing, and it won't get called. And, the general idea is that, we know that this isn't allowed, but if we do it just a little bit, the referee is not going to call us on it. And if the referee in this case is the judge, that might have been the case with these stockholder agreements, right? That when you overstepped the Delaware pattern just a little bit, it just wasn't worth anyone's time to really challenge it in court, but you kind of knew not to go too far. We now have a Delaware statute that basically says it's not entirely, but it's pretty close to open season to do these things. It's almost like the basketball rules got changed and say, it's okay to grab someone else's jersey. Don't be too bad about it, but go ahead and grab someone's jersey. I think it's going to change the way that the team plays defense. I think it's going to change the way that these contracts get executed, because they have a little bit more of a hall pass now to engage in creative contracting. And that's what good transactional attorneys do. So when, it looks like what they have been doing is now something that the Delaware legislature says, okay, the next logical thing to do is to try to test the boundaries of that, to try to figure out if there are ways that you can use these contracts in a manner that overrides what sort of fiduciary principles would otherwise entail. Now, the Delaware Assembly basically said, we're not changing fiduciary law, and they say so specifically in the statute, but it's really hard to know whether that's going to prove true or not, because if you've got a contract and the contract is just getting complied with, and the contract also isn't getting disclosed to other folks, which is a big potential danger here, who's going to enforce the fiduciary obligations? Who's going to even know about the existence of the contract? And so I think that one of the areas where I was a little bit alarmed isn't as much the idea that you shouldn't be allowed to use contracts, but the fact that this was a change that was made pretty much for every Delaware incorporated company. It says it's now okay to do this. It's not clear that the shareholders who invested in those companies had assented to that, and now that's a rule they're going to have to live by. And for many of these companies, particularly the ones that aren't publicly traded, these stockholders may not even know that there's a favored stockholder that has extra influence at the board level, or maybe even a prospective stockholder who's not even a stockholder yet, who has that kind of influence at the board level. And so that's one of the things that I think is a bit of a concern, is that with this new license to generate these contracts, transactional attorneys are going to do what transactional attorneys do, which is they're going to then try to test the next boundary out. And if you didn't do that as a transactional attorney, I'd say you're not doing your job.
Coming up, more with Professor Eric Talley and the latest on the Elon Musk Tesla pay package. You're listening to Bloomberg. I've been talking to business law professor Eric Talley of Columbia Law School. Eric, let's talk now about a subject that we have discussed once or twice before. Elon Musk's legal fight to save his $56 billion Tesla pay package. Last week, Musk's attorneys were back in Delaware Chancery Court to ask the judge who blocked the deal to change her ruling. And Chancellor Kathleen McCormick said, "This has never been done before. There's no Delaware law on this, correct?" Tell us what Musk's lawyers were trying to pull off here.
Yeah, it's sort of an interesting thing. People haven't really tried this approach before, I think largely because no one expected that it would have any traction. But the idea is that the compensation package was clearly a situation where this large controlling stockholder and board member and CEO had a conflict of interest. And Delaware often scrutinizes contracts or transactions with a conflict of interest with a specifically heavy hand. And so if you're going to try to defend that contract, there's only a couple ways to do it. And some of them aren't very clean. They just involve protracted litigation. But one way to do it is to say, hey, we got approval from the stockholders and maybe even independent board members, and even better, both of those groups to go forward. Any one of them would help. And so when Tesla first granted this compensation package to Mr. Musk in 2018, they did go out for a vote of the stockholders. But Chancellor McCormick basically said, you know what, you didn't accurately disclose all of the tomfoolery and shenanigans that were going on at the board level when it came to putting this package together. And so when the stockholders voted on it, they were voting on an incomplete basis of information. And so you get one chance to do this, you didn't do it right, and she invalidated the contract. So what Tesla did is that it said, okay, we're going to go back out for another vote of our stockholders. We're going to make all kinds of disclosures to them, including attaching the entirety of Chancellor McCormick's opinion, and get another vote. And that's what happened in June. The stockholders came back and voted, 72% to validate the compensation package. And then, everyone sort of expected that this was going to happen. The Tesla attorneys came forward and said, okay, so this really just counts as stockholder approval. Yeah, we got it way after the fact and after we had already lost with a defective stockholder approval, but it should have the same weight. It should carry the same weight as if we did it right the first time. And this clearly troubled Chancellor McCormick, because there's almost sort of a question of, if this were, something that she could sign on to, does it basically give companies license to try, an infinite number of times to try to get stockholder approval, even years after they've gotten, an adverse judgment against them? And that has never been tried before. This particular approach is one that I think probably most students of Delaware law would say it's a bit of a long shot, but Elon Musk is known for taking long shots, and so we'll see how this comes out. And I think in some ways the debate over the new statute in Delaware, bears some relationship to this. It's not really a compensation sort of issue with this new statute, but it does deal with influential stockholders who get into contracts with companies. Delaware came under a lot of fire, at least from Mr. Musk and his acolytes, for invalidating the contract. On some level, the Delaware legislature might have been, working on a little bit of concern that they wanted to signal to people that, no, we're friendly to big stockholders. And so here's a way we're going to do that. So it'll be interesting to see, how these two things kind of progress simultaneously. The new statute is now law. We don't know exactly how people are going to be responding to it. I will tell you, June, that as someone who, basically makes a living studying how different sorts of legal rules change corporate behavior, even though I'm a little concerned for the Delaware franchise here, it's going to be a gold mine of new data to study, right? Because this is a fairly significant and by some lights risky experiment with Delaware law. And so we're just going to have to see how it plays out. And then at the same time, we've got, Chancellor McCormick is going to have to come up with some sort of fee allocation, and maybe even she might even be convinced to revisit her ruling. That if she decides not to do so, I suspect she probably won't revisit the ruling. Then it'll go up to the Delaware Supreme Court, and so we may have more fun and games with Elon Musk as well.
What I thought was really interesting was her concern that, you might have investor votes overturning trial judgments. She said to the Tesla lawyers, if shareholder votes aimed at overturning a ruling could occur at any time in the legal process, quote, when does it end in your world?
Yeah, and I think the answer may be never. So, it's hard to sort of say, oh, no, it only ends at the second vote. Why would it end at the second vote? If the magic is that you can come in after the fact, clean everything up with a full disclosure and get stockholders to approve it, then if you fail the second time, and there's actually an argument that when the stockholders voted this time around, they had a lot of information. They were fully informed, but they were also really concerned probably about statements that Mr. Musk had made that he was going to remove the AI assets from Tesla and do them somewhere else. So the key thing on a stockholder vote is you got to be fully informed, and you can't be voting with a metaphorical gun to your head. So there's a chance that this second vote, even if it would count, would be invalidated because of what's known as coercion of the vote. Could they come back with a third vote if that's what happened? And it's really hard to know what is in store, as it is always hard to know what is in store with Elon Musk. I predict that Chancellor McCormick is probably going to stick to her guns, if for no other reason that, there's a developed record, this can be sent up to the Delaware Supreme Court, and then they can kind of take a second pass on it.
Speaking about Delaware judges and the importance of Delaware courts, does the amendment that we were talking about imperil that in any way?
Another important question, in addition to whether stockholder agreements can leapfrog the charter and the bylaws, is who gets to do the enforcing. Because, Delaware has long basically been very jealous of using its own court system to enforce corporate law. And that's one of the reasons that Delaware has become such a center for corporate law, is that the judges have so much expertise. Once you start to allow contracts to have this kind of overarching governance power, you may end up kicking into gear things that go beyond Delaware law. What if you have a contract that says, oh, this is going to be heard in California or in Texas or in New Hampshire? Is that something that's going to basically pull stuff out of Delaware law, including the judgment of whether this contract was consistent with fiduciary duties? Are we going to have a California court deciding that? In addition, there is a federal law that says that if you enter into a contract that says we're going to have arbitration, federal law basically requires you to, as a court, to surrender jurisdiction to a third-party arbiter. So it could be the case that you have one of these stockholder agreements that really does come close, if not does violate fiduciary principles. That says, hey, there's an arbitration provision in here. It's not even going to land in front of a Delaware court. This is going to go in front of, someone. It could be you or me who's the designated
I
arbiter.
hope it's not me.
Yeah, well, I kind of hope it's not me as well, to determine not only how do you enforce the contract, but whether the contract is consistent with fiduciary principles. And so one of the other areas where this statute could go sideways is that, Delaware may have shot itself in the foot in terms of its ability to keep control over how its companies get adjudicated in courts. If, in fact, doing things through contracts cause corporate governance to get adjudicated in front of arbitrators or in front of non-Delaware courts, there is no guarantee that those other judicial or sort of judicial actors are going to have the same view of what fiduciary principles entail. And if they don't have the same view, then, even sort of saying, don't worry, fiduciary principles are still in play, is kind of an empty consolation, given that it's not even Delaware judges who are going to be determining whether the contract that's at dispute ends up offending certain fiduciary principles. And that we just don't know the answer to. But I certainly would expect that one of these creative transactional attorneys might start playing around with arbitration provisions or choice of forum provisions that cause the dispute to wander well outside the borders of Delaware.
Thanks so much, Eric. It's always enlightening and fun as well. That's Professor Eric Talley of Columbia Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.